Hi, I'm Andrew Goodson, and today I'm going to be discussing some views of the insolvency profession from outside of the industry, and in particular what appears to be a campaign for change in the regulatory regime of the insolvency industry by a parliamentary group. Now, given some of the work carried out by Griffins as a successor practitioner in various roles, we do have a keen interest in the regulation of the insolvency profession, and in particular whether it's working and what changes might perhaps bring about better results. However, I first wanted to look at what's been going on, particularly with this parliamentary group, and what they are seeking to achieve. Now, in July last year, the All-Party Parliamentary Group on Fair Business Banking called for changes to the regulatory framework, leaning heavily on potential conflicts of interest by office holders. They name-checked BDO regarding One Blackfriars and Deloitte on Comet. They suggested that these were a failure of regulation, in particular the matters that the regulators have looked into. Further, they added that they felt a tribunal was needed in order to allow stakeholders to air their grievances. So the first thing to do is look at who is this all-party parliamentary group. It was formed as the APPG on interest rate swap mis-selling to campaign for the plight of many small businesses who were sold products that they didn't understand and oftentimes didn't need, which when the economy went south caused some fairly hefty charges to be incurred, and I'm sure many of us have dealt with cases where the refunds have come in as a result of some of that work. The remit has since widened to deal with effectively the imbalance in bargaining power between smaller businesses and the large financial institutions that provide the banking services. Now, the first point that I note is the cases they highlight don't really appear to be a failure to take any action. In all of them, the regulators and the appropriate bodies are already looking into these matters. And to take that one step further, I don't think there's much you could change in the regulatory regime that would have allowed the regulators to stop these things from happening before they did. So it feels a little bit like they're kind of putting the cart before the horse, and they're not following through what's actually happened. And they even mention the fact that there's legal action being taken against BDO and the fine against Deloitte. They also mention times where the IPs are potentially in conflict. Now, this is a very real risk. One of the common phrases around Griffins is that to be an IP in office is to be conflicted just by the nature of the role. And the most important thing is never to lose sight of that so that you can always deal with it. And the examples that were used here for where conflicts of interest are causing issues aren't ones that I would use, because in all of the examples they gave, they were talking about where the IPs in office identified there was a potential conflict, usually the fact that they were on a bank panel and it looked like there were claims against that bank. And so they've then got a insolvency practitioner from a different firm in so that any conflicted matters can still be dealt with appropriately. Now, that to me is not a conflict of interest causing problems for stakeholders or creditors losing out. That's a very good, well-regulated professional being aware of the limits of what they comfortably feel they can do, and where what's necessary goes beyond that, they are passing that on to another professional and arguably losing some of their own fees in order to make sure that the creditors get the best result possible. So I don't agree with their initial conclusion from this report, which was that because there was this potential conflict, which on their own cases is being managed, all bank panels should be banned. As I think anyone could see, if you banned all bank panels, all you would really do is ban publicly known bank panels, and you would have unofficial bank panels where the people who have the power within banks to make decisions would still have the same firms and individuals that they've had positive experiences with previously that they would want to give the work to, and it would, if anything, it would be harder for anyone outside to keep an eye on that panel. as I said last year, I would actually argue to go the other way, that the panel should be more formal, they should be very public, and anyone on it should very clearly, be saying they're on it. And it felt a little to me like the APPG is offering attractively simple solutions to what are actually far more complex problems. The more complex issue is the examples they've given are good examples for where the IPs have identified their conflict and got another IP in to deal with any conflicted matters. The more nuanced question is, how do we find out if that doesn't always happen, and how do we try and deter that from happening? And just banning bank panels isn't necessarily going to do that, because if you don't know that the firm is on a bank panel, how can you even know to be carefully keeping an eye on what they're doing? So I think that's, as I said, a public panel does give a better visibility, particularly if the IP has to announce in the first couple of bits of correspondence that go out to creditors of that relationship, so that if the creditors do feel it's material, they can then have a closer look and, if necessary, make suggestions for another IP to be appointed to assist with the bank-related matters. And more recently, the APPG has put out a call for evidence in relation to insolvency work. Now, I understand this call may now have been widened somewhat, but originally, as it was reported, they sought the views of major accounting firms, the regulatory bodies, and the insolvency service. Now, first of all, it's not clear where they draw the line of major for accounting firms. Do they only really mean the big four? How far down do they come? And also, would they include firms that aren't traditional or all-service accounting firms but are still very sizable in the marketplace? The two that immediately spring to mind would be FRP or Begbie's, where they are nationwide, huge number of offices, huge number of staff and IPs, but because they don't offer accounting services, they aren't in the big four, might not be included in this call for evidence. And I wonder if some of this is the approach of someone who doesn't have a long involvement in the insolvency industry and is looking in from the outside and perhaps not entirely understanding what goes on. As most people would know, there's a whole world of insolvency that takes place underneath the level of the Deloitte doing Comet and PwC doing Lehman's. There's a whole world of much smaller administrations and liquidations going on, where the experiences of creditors, of the IPs, and everyone involved is very different. Particularly your nil asset or very low asset cases, and it almost feels like they're looking in naively from the outside and seeing what they think are obvious fixes that don't turn out to be that way. It reminds me of Mr. Justice Ferris when he complained of the profoundly shocking fees of the receivers in the Maxwell case, but then after it was kicked off to the Chief Taxing Master to look at the receivers' claim charges, the Chief Taxing Master says, well, actually, having looked at it and the work they did and the work they had to do, it was all fine and it was all allowed in full. And so I wonder if there's a misunderstanding on the part of the all-party parliamentary group as to exactly what's entailed in insolvency, and as a result they're coming to some wrong conclusions because they don't have the full picture. Now, I doubt the call for evidence will form the basis for any proposed changes directly, but it might form the basis or influence perhaps the next call for evidence from the insolvency service or the regulatory bodies across the industry wider. And so it will be interesting to keep an eye on what comes out and how their campaign goes. And moving on to one of the other points they raised in July and more recently, was they talk about the lack of an insolvency tribunal or ombudsman. Now, whether there should be some form of access to challenge decisions that doesn't have the upfront fees of a court process or not is an interesting question, and I think it's one that goes, to debate that fully would go beyond the remit of this video. However, just as a quick counter to that, I think the highest fees you're likely to pay on any insolvency application is about £280. So it's not a truly limiting sum, and there is an argument that it does help deter perhaps some of the more vexatious litigants who aren't prepared to put quite so much money into their applications. Perhaps more telling was their complaint less so about the different types of tribunal in which one can challenge an IP's decisions, but more the fact that because an IP is an officer of the court, it seems to be their complaint that because you're an officer of the court does look more favourably in what you're doing. We all know that the courts take a very slow approach to criticising anything on a commercial basis that an IP does because of their wide remit. And so that seems to be the centre. They've complained, about the conduct of IPs at some point, or someone who's complained to them has, and the court has said, well, actually, because this is an officer of the court, because of the standing of what they're doing, I find it hard to believe that what you've alleged is actually what's happened. Now, I would be very much against any adjustment to the balance of the court when viewing the actions of an IP. If you think about it, no other professional who has to go through so many hoops to take office, the JIE exams, the professional indemnity insurance, the bonding, both specific and general, and is then quite often parachuted into something they know little about other than what interested parties, be it creditors or the directors, have told them, and are then taking on such huge amounts of personal liability from that moment that they go in, rather than from the moment they've had a chance to look around and take a reasonable view. Now, given all of those risks and downsides to what's being done by an IP, I think that it's a very fair trade-off that the court is not quick to say, well, now I've looked back on things, Mr. IP, I actually think you could have done this slightly better, so you're going to have to pay some money or redo a decision you've come to. And as I say, I think the courts have the right balance. They leave almost all commercial judgments undisturbed. And there's a second reason why I don't want to change this greatly, and that's because I don't think the facts and figures back up the claims that the parliamentary group seems to be making, that there are a large number of stakeholders out there who are being ill-served by insolvency practitioners, are desperate to make complaints but cannot have their voices heard. And this comes from another point they've made, which is they have linked the complaints about the tribunal to the lack of a single independent regulator. Now, this is something that's rattled around the industry for some time, and the argument is that there shouldn't be a regulator who, on the one hand, is an industry trade body for those professionals, and on the other hand has the responsibility to regulate their conduct and review complaints. Indeed, this is what led to the SRA splitting off from the Law Society. I think the argument has different strengths depending on which of the two main regulators within England and Wales one looks at. Prior to sitting down to record this, I looked at the ICAEW regulatory board for IPs, and I couldn't see any IPs on there, or anyone who's ever really worked in or traded in or touched on insolvency. It was generally a makeup of some people with a legal background and other people with an audit or compliance background who've then moved into these sorts of roles. And then when you think about it, insolvency practitioners make up, I think, fewer than 600 of the Institute's 150,000+ members. And so when you look at it that way, insolvency practitioners are such a small part of the Institute's business. The Institute doesn't care if they're going to upset a few IPs by perhaps being harsher with their regulatory regime. The Insolvency Practitioners Association is a little bit different. It does have IPs on its boards that are looking into the conduct of IPs, but it's still only about half, and on the other half it's got quite a heavy lean onto both lawyers and then some lay members, and it even has a former chief registrar, so who's going to carry weight in their views of what's been done by the insolvency practitioner. But even so, the makeup of the board is not evidence in and of itself that the regulator is taking a softer view of the actions of its members. And indeed, this is something that the Insolvency Service has I think, been aware of and had an eye on for some time. I mean, for some years now, there's been a centralised portal for making complaints to IPs, as I'm sure most of you know. No one now complains directly to the regulatory body. You go onto the Insolvency Service website, make the complaint, and they deal with them. And as a result, they also monitor the complaints, and if there was an issue with a number of complaints wanting to be made, but the regulators not looking at them, you would expect the Insolvency Service already has the numbers and would already be making noises about it. I looked at the figures, the most recent figures that have been published by the Insolvency Service, and these were for 2019. Now, complaints have risen. They are up to 856 from 757 in 2017, which is a modest increase, and it causes one to ponder and look a bit further. However, once I drill down, you can then see that half of the complaints made to the Insolvency Service progress no further. So these are complaints where so little information is provided even after the Insolvency Service asks for more, or where the complaint is so ill-founded or nonsensical, as examples, the Insolvency Service doesn't even hand it on to the regulator. The Insolvency Service, as a completely independent body, says there's nothing in this and it's a waste of anyone's time to go any further. Of the 428 complaints in 2019 that were passed on, 99 relate to SIP3, which, for anyone who's done their JIE knows, that's the voluntary arrangements. And I would expect there you're going to have quite a heavy involvement of the volume IVA market. Now, that business model and the IPs that practice there, it's very different to general insolvency, and it has its own bespoke issues that doesn't really affect the greater number of IPs who do more generalized work. So then looking on, a further 107 relate to communication breakdowns or failures, which, you know, it can happen to any of us, where, you know, communication wires get crossed and then the creditor gets upset because they perhaps aren't as versed in insolvency as we might expect people to be, or we can sometimes forget that people aren't quite so well versed in what can be quite complicated processes. But these communication failures, these aren't going to be people who've desperately lost out because there's a conflict between the IP and a bank and the IP is not taking certain action. This is generally about people who've rung up and want to know what's happening with their claim and don't feel they've had their question answered. So after that, you're then left with just 222 complaints made in a year. That affects everything else that the insolvency practitioner might be doing, where the Insolvency Service has received the complaint and feels it's worth passing on to the regulatory authority. So this isn't 222 cases where IPs have found to have failed in what they're doing in those matters. It's only that within a year, you know, only 222 cases where the Insolvency Service has received a complaint on the more general conduct of anything that could be happening in the formal insolvency process, and they've decided it's worth passing on to the regulatory body to see whether there's anything in it. And so I think, in conclusion, we certainly have some ideas on potential improvements that we believe could improve the industry, but for us they are very much evolutionary, not revolutionary. Two immediate thoughts I have might be of use going forwards would be, firstly, I think it's worth exploring and considering the independent regulator point, not because I think there's any possible conflicts or bias or any issues like that, but only because it's what happens in most of the other regulated professions. There's the FRC to keep an eye on auditors. There's the SRA is split off from the Law Society for solicitors. So rather than it being, for example, a negative change because we think there's something wrong with how the industry is being regulated now, it would more be on a positive case of it's something that other professions have looked at and they've decided it's something they think they should do. And so we should probably explore, do those same factors apply to our profession? Now, I'm not saying for certain that they will, and it might well be that after a considered review, it's decided not to change anything. but it's one of those things I would like it explored in a, if you like, a more rational and less heated arena. So rather than it being in the arena of there's complaints, there's people that are upset with what's happening and it's not working well, I would rather it's in the arena of why are we different to the other professions, and might that cause us to be viewed more dimly, and would we actually perhaps have more respect overall within the economy if we took this change. And if that was felt to be the case, then I think that's a strong case for why we perhaps might consider it. And the second point we occasionally ponder is whether there is scope for the second non-associated vote within liquidations and bankruptcies, particularly when looking at the appointment at the outset of a case. If one considers administrations and voluntary arrangements there, as well as getting a certain majority of the votes, there's the second count where you look to see, have you got more than 50% of the third party creditors. Now this is to stop you get the odd rare occasion where in a voluntary liquidation it looks like creditors who are perhaps hostile to the insolvency practitioner the directors have approached suddenly find on the day that the director's loan account is enough to dwarf everyone and the director's choice of IP gets the job. Now this isn't a major and huge issue within the industry, but again, a bit like the last point, is it one that by making it, it could improve the how the industry is viewed by a number of different stakeholders. But they are just points to debate possibly at another time. So in conclusion, we've reviewed cases run by myriad IPs and firms, and generally speaking, our findings are that the vast majority of IPs are acting like well-regulated professionals who are aware of the issues in the roles they face, and in particular the potential conflicts, and do their best to avoid it. Those that don't fall into that category are few and far between, and so because of that I am very slow to warm to the idea being put forward by the parliamentary group that there are fundamental issues within our industry that desperately need dealing with by swathing changes, carving up massive amounts of what we do, without there being good detailed evidence behind what they're asking for. Now it may be interesting to see what comes out of their review, but I doubt there's going to be anything that causes us to change our mind yet, but no doubt others will have different views, and I'd always be interested to hear your views. So hopefully you've found this review of the view of the profession from outside interesting. One or two may even find it surprising, the broadly positive view we have, but as I said, that's where we are, and we feel any changes very much should be evolutionary from discussions within the industry rather than people from the outside who perhaps don't really understand exactly what happens and what goes on trying to completely change the landscape. And other than that, thank you very much for listening, and I hope you've enjoyed this and you have time to check out the rest of the Dodging Bullets season.